Good morning, students. I am going to take the subject is today business law. First, we are going to see the definition of business law. Business law is the body of law that governs business and commercial transactions. Business law lays down the rights, duties, and obligations owned by parties to a contract. Now we are going to see the difference between contract plus agreement. Agreement is a written or verbal contract between two or more than two parties which is not enforced by the law. A contract can be defined as a verbal or written agreement between two or more than two parties and is fully enforced by the law. In agreement, an agreement is simply an understanding or arrangement between two or more parties. In contract, a contract is a specific agreement with the terms and conditions that are enforceable court. In agreement, an agreement is usually an informal agreement, often unwritten between two or more parties. In contract, a contract is a specific agreement with the terms and conditions that are enforceable court. Now we are going to see nature of contract. A contract is any agreement enforceable law. Second, never enter into a contract without understanding the legal responsibilities involved. Third, not all agreements are contracts. Fourth, a promise of future performance. 5, a set of promises forming consideration of each other is agreement. 6, agreement must be at the option of both parties and not at the option of one. 7th one, void if not enforceable by law. Now we are going to see the classification of contracts according to enforceability, that is legal viability. The subpoints are valid contract, void agreement, void contract. The 4th one, voidable contract, illegal agreement, unenforceable agreement. Second, according to formation, that is mode of creation, in which we are going to the subpoints express contract, implied contract, quasi contract. The third area, classification of according to performance. First one, executed contract, executory contract. Now we are going to see the essential elements of valid contract. First one, offer and acceptance. Second one, intention to create legal relationship. Third, lawful consideration. Fourth one, capacity of parties. Fifth one, free consent. Sixth one, lawful object. Seventh one, lawful consideration. Eighth one, certainty and possibility of performance. The ninth one, legal formality. Now we are going to see the contingent contract and discharge of contract. Contingent contract. The contingent contract is a contract in which a promise is conditional and the contract shall be performed only on the happening or not happening of some future uncertain event. The discharge of contract. The discharge of contract refers to the termination of contractual duties or dissolution of contract. Discharge means to remove liability or to be released from liability. The various modes of discharge. Shall be a 4, by performance, in which actual and attempted, by impossibility of performance, by lapse of time, by breach of a contract, in which 2 points are there. 1, actual and anticipatory. Again, it can be classified into 2 areas from mode of discharge of contract by mutual agreement. In mutual agreement, there are 6 points are there. Novation, recession, alteration, remission, waiver, merger. By operation of law, there are 4 points are there. Death, merger, insolvency, unauthorized alteration. Now we are going to see the quasi-contract, contract of indemnity and contract of guarantee. The quasi-contract is a contract that is created by court order, not by an agreement made by the parties to the contract. The contract of indemnity can be defined as a legal contract between two persons whereby one party commits to indemnify, that is compensate or reimburse the loss incurred to the other party by the conduct of party who is making the promise or by the conduct of the third party. The contract of guarantee. A contract of guarantee is a contract to discharge the liability of third person in case of his default. The contract of sale of goods, partnership, and negotiable instrument. The contract of sale of goods is a contract whereby the seller transfers or agrees to transfer the property in goods to the buyer for price. There can be contract of sale between one part owner and another. A partnership is a kind of business where a formal agreement between two or more people is made and agreed to be the co-owners distribute the responsibility for running an organization and share the income or losses that the business generates. Negotiable instrument is that document that includes a promise to pay certain amount of money to the bearer of the document. Is a mode of transferring debt from one person to another. Negotiable instruments always a written form. Example, check, promissory note, bill of exchange. Thank you, students.